Hello. If you could, you can convene again, and if you come again, this is going to be our second panel, and we're going to start right now. It's our legal panel, Law and Legality, and as I mentioned, this explores the constitutional, statutory, and international legal foundations for the use of military force against transnational criminal networks and the precedents such actions may establish. Our moderator, John Hasnes, Professor of Business and Professor of Law by Courtesy at Georgetown University. And our speakers are John Habranek, and John is counsel of Nixon Peabody LLP and former principal deputy. Nathan Goodman is senior fellow at the Mercatus Center of George Mason University, and David Vandenberg, attorney advisor, the Civil Rights Division of the U.S. Department of Justice. Thank you for being here. It's a pleasure. Welcome to Contra at George Mason University, the Schar School of Policy and Government. Thank you.
Thanks very much. Okay, my name is John Hasnes. I'm the moderator for this panel. The way we will proceed is each of our panelists will take about 7 or 8 minutes and introduce the topic that they're addressing. We'll then take a little time to have the panelists exchange and talk back and forth, and then we'll have the majority of the time, or at least half the time, for questions and answers from the audience, and I will try to keep track of who wants to. Do you have them lined up here? I can keep track of who wants to ask questions, but if you just line up here, I guess I don't have to. All right. Very nice. Okay. The first speaker is going to be John Habranek, and he's going to talk to us about the history and legality of using military force and post-war changes to international law regarding the use of force, obligations under the UN Charter, and a brief description of the difference between armed conflict and law enforcement actions. That'll be followed by Nathan Goodman. He's going to discuss how economics offers important lessons about the dangers of secrecy and militarism, and that will be followed by David Vandenberg, who will discuss the current administration's use of law to enforce the border, and in particular the Alien Enemies Act, and discuss the nexus between law enforcement and military practice and how that's becoming blurred. So with that, I'm going to let John start us off, and you may begin.
Thank you very much, John. You can see from the last panel there was a lot of discussion about using military force, particularly with the designation. So I'm going to talk a little bit about when is it actually lawful under international law to actually use military force, and to give a little bit of history of how things evolved. So like prior to 1928, before World War I, it was actually lawful as part of diplomatic relations to use military force against another country. You heard Alan Burson talk about Theodore Roosevelt threatening military force. Theodore Roosevelt threatened military force for the Panama Canal to be able to get to where we're doing, because using your military and attacking someone was just another means of diplomacy that was available. Well, after World War I, we had the Kellogg-Briand Act, as well as the League of Nations, and the international community essentially put a prohibition on using military force as a means of diplomacy. And that really came in to be the aspects of international law after World War II. So that got actually strengthened, as well as after World War II, the law of war developed that said that there's actually rules about doing military actions. For instance, in World War II, the United States firebombed both Germany and Japan. Today, that would be a war crime. It would be an illegal act. You're required to use discrimination, not go after civilians when you do those sorts of things. Now, the other thing that happened after World War II is we had the UN Charter. And the UN Charter is an actual treaty. It's an agreement that the United States is a party to, and under our Constitution, a treaty has the same force and effect of law as if Congress passes a statute. So the UN treaty is as much of domestic law as it is international law. But there's two aspects of the UN treaty that are the charter that's out there. So one, Article 2, subparagraph 4 says another nation cannot use force against another nation as part of international relations. And there's only two exceptions to that. And the first exception is when it's authorized by the Security Council, which is done under a Chapter 7 peace enforcement type operation. We had that in the first Gulf War in Iraq. We had it in military, the multinational forces in Haiti. We had a UN security resolution in Yugoslavia. You had international forces that went in, the military used them, the United Nations did it. The second aspect of when you can use military force is in self-defense. So when they put the charter in, they said, well, if there's a threat of force or an actual use of force, a nation should be able to defend itself. And the Article 51 specifically says that if you're going to do that defense, it must be against an armed attack. Now, there's been a lot of discussions about the drug cartels. Is selling drugs or fentanyl killing 80,000 people in the US, is that the equivalent of an armed attack? I will say it's not. That has never been that way in the way we've looked at it in the United States as far as law. That's not the way it's been internationally. Now, why would I say that? So when we put these laws in place, it was specifically about armed force and the type of force that you would use with a military. Because we use other aspects of force, we just don't call it. Economic sanctions have significant impact on other countries. It affects their economies. It could affect, the ability of people to get medical care and other aspects of that. And it was specifically said that those types of actions do not equate to an armed attack. And let's move forward. Let's look at technology. What about cyber attacks? Is a cyber attack an armed attack? So every time the Russians try to steal something from IBM or someone comes in and does a hack on something, is that something that we, the United States, or other countries should be using military force to, bomb or attack other nations and say that we're doing it in self-defense? Typically, the way that the United States government's position has been is that it must equate to something similar to like an armed attack where you're going to cause death, some sort of destruction, those types of things, to where a nation can say, we are going to use our military to actually defend ourselves under Article 51 of the United Nations Charter and actually to do those types of things. So as we've looked at the history, you have two aspects of the law of armed conflict. The first is the law that allows you to go to war. And then once you go to war, the question is the law of war and how you actually conduct your actions and what you're authorized to do when you take those types of actions. So in looking at going to war and what we've done with FTOs and using military action against them, are we going against a nation state or are we going against non-state actors? And where does that other aspect of the United Nations Charter about the prohibition of using force apply? Well, the Charter is specific to states. It does not say anything about non-state actors. And so as far as Article 2, subparagraph 4, where we have hit cartels in international water and it has not been on land, on terra firma of another nation, we haven't violated their sovereignty or within their territorial seas, that in and of itself has not violated Article 2.4 of the United Nations Charter. So then the second question is, are we actually acting in self-defense when we're actually taking those sorts of actions? And what are we defending ourselves against? That's a little bit harder because if you look at the drug cartels, everything you heard from the last panel, and even when we had discussions before, everyone has talked about the goal of the cartels is to make money, not take an action that is opposing the United States government, overthrowing the government, undermining our way of life or anything like that. It's all about making money. And as reprehensible as it is, and as illegal as it is, and the unfortunate consequences it has in our nation, you have people supplying drugs, you have dealers, you have people then voluntarily purchasing drugs for illegal purposes and dying because of it. But the attenuation between saying it's an armed attack for what we would go after like Al-Qaeda for, and saying that it's a drug as an armed attack, we have never been that way before in the way we've interpreted international law or the way we've applied international law. The other thing I want to talk about is non-state actors. I've said it's okay to defend yourself against non-state actors because we clearly in the United States have taken that position with Al-Qaeda. We are, not everyone shares that opinion. There are many that read the UN Charter and say that you actually have to be physically attacked and before you can respond in self-defense. The United States position is no, you can defend yourself against non-state actors and you can react in what is known as anticipatory self-defense, meaning you don't have to take that first punch on the chin before you actually defend yourself. But you have to look at what's happening, and it has to be an imminent attack before you can actually, take some sort of military type operation. Sir, did I go by my time already? Okay, so the last thing I want to talk is the difference between military force and law enforcement. Under the law of armed conflict, it is status-based. Once you determine someone is a hostile force, the National Guard of the Iraqi government, you attack them based on their status, and you go to kill them first. You don't have to start from zero to going to lethal force. You can use lethal force, and you kill them simply because of their status, and you have combatant immunity that you're not liable for murder or crimes like that. For law enforcement, it's the opposite. It's defending an individual, and you start at the bottom spectrum of force, and lethality is the last thing you do, and you only do that to protect where there's severe injury or damage to life and others. So, we can talk about this later, and I hope we also get to ask some questions about non-international armed conflict, because right now we in the United States have said we're going after TDA and these drug cartels as self-defense under Article 51, and then we've subsequently said we're in a non-international armed conflict with them as well.
Wonderful. Thank you so much. And thank you to the organizers of this conference for the invitation and the opportunity to be here and learn from all of you. So as we've been discussing, the current administration is increasingly pursuing a militaristic strategy to combat drug cartels in the Western Hemisphere. They have designated them as foreign terrorist organizations, and notably, as part of their efforts to stem the flow of drugs into the United States, they have bombed at least 46 boats and killed at least 157 people so far. I say at least, partially because when I got those numbers, it was a week ago, and there has been at least one strike since then. So some people might view this favorably. After all, the cartels hurt people. They hurt people with violence. They import drugs into this country that people become addicted to and that people die of overdoses from. These are serious human costs. But is this the appropriate way to fight them? I think that's an important question. 157 people have been killed in these strikes, at least, so far. 157 human lives snuffed out. Were they all actually trafficking drugs? Were they all members of these cartels, these transnational criminal networks? Were they all terrorists? Is that an accurate way to identify all of them? And importantly, was it legal to kill them? Now, I'm not a lawyer. I am trained as an economist. So you might ask, why am I on this panel? And the reason is because economists study how people make choices, the incentives they respond to, and how those incentives shape their decision making. Laws and the interpretation of laws shape the costs and benefits faced by decision makers within the United States government. Therefore, economics gives us tools for analyzing how legal interpretations will shape the incentives of officials in our government and what we should anticipate as the results of those incentives. This economic approach to analyzing law raises two concerns for me. The first is that many of these decisions are being made secretly, and this limits our capacity to hold decision makers accountable and creates scope for opportunism by public officials. The second is that those involved in these operations, by practicing these militarized approaches to counter-narcotics enforcement, acquire skills, tools, and experience that they can then reapply in other contexts. And I believe that this may have adverse consequences for civil liberties down the line, including in the domestic interior. So let's address the first concern, secrecy. Secrecy surrounding militarized operations creates substantial scope for opportunism by the powerful, and it makes it harder to hold decision makers accountable. What is the administration's legal justification for these boat strikes? Well, they have an Office of Legal Counsel memo drafted by the Justice Department's Office of Legal Counsel, or OLC, that authorizes a broad range of militarized actions against cartels. Journalists have reported, citing sources from within the government, that the memo designates a list of cartels that goes beyond the administration, those the administration has publicly designated as terrorist organizations. And notably, this memo is classified. You're not allowed to see it. Only those within the government are. The American Civil Liberties Union, or ACLU, and the Center for Constitutional Rights have filed a lawsuit under the Freedom of Information Act, or FOIA, seeking the release of this memo. When the legal rationale for state violence is kept secret, this makes it harder for ordinary citizens to challenge the application of that violence and to interrogate and investigate the legal rationale. Suppose you wanted to learn or apply what you learned from John's excellent remarks about the law of armed conflict and say, well, does this OLC memo comport with our understanding of the law of armed conflict? Well, if you're not allowed to read the memo, you can't exactly assess their arguments and say, oh, is this consistent with what I just learned from John or not? You don't have that capability. Ken Cuccinelli just mentioned on the last panel that he had sued the Obama administration over the NSA's collection of metadata on ordinary Americans without a warrant. Well, the reason that he knew that they were doing that and that there was cause of action to sue them was that the metadata collection, which had been kept secret, was disclosed by Edward Snowden. Had it remained classified, Ken Cuccinelli would not have known about it enough to then file a lawsuit to try to prevent this assault on Americans' civil liberties. So our ability to check government power is constrained by the information we have on government power. This is an example of what economists call asymmetric information. And understanding the incentives of government officials in this way raises serious concerns about making decisions under a veil of secrecy. My second concern is that militarized policies have long-term effects because those involved in executing militarized policies can develop and expand their coercive powers and skills to a greater degree than they would ordinarily be able to if they were simply operating within a, say, domestic law enforcement capacity, right? So let's think about this concretely. This is an argument that was made by my colleagues, Chris Coyne and Abby Hall, in their excellent book, Tyranny Comes Home, The Domestic Fate of US Militarism. And one example that they used to illustrate this is the creation of SWAT teams. So the first SWAT team was established within the Los Angeles Police Department, or LAPD, and it was the brainchild of John Nelson, who had served in an elite force recon unit in the Vietnam War. These teams killed around 34 enemies for every man they lost. And John appreciated what he had learned participating in these teams and wanted to apply those lessons to domestic policing. So he started the first SWAT team. Now there are SWAT teams all over the nation. They kick down people's doors to execute raids. They engage in armed and militarized policing all over the US. This is in part a downstream consequence of our foreign policy. Now, sometimes these SWAT teams, such as the Border Patrol's top SWAT team, the Border Patrol Tactical Unit, get involved in foreign counter-narcotics operations. So for example, back in the late 80s and early 90s, the Border Patrol Tactical Unit was involved in what was called Operation Snowcap, which was a counter-narcotics operation in Latin America. Now, since then, they've been involved in all sorts of domestic law enforcement efforts, including policing of protests. For instance, policing of protests in the aftermath of the killing of George Floyd in 2020. We can think about the use of drones as another example of this effect of foreign militarism on domestic civil liberties, right? So for instance, drones, unmanned aerial vehicles, were initially used by the DoD for targeted killing operations and surveillance operations as part of the global war on terror. They were then adopted for surveillance use along the US-Mexico border by the Border Patrol. However, CBP has lent their drones hundreds of times to other law enforcement agencies, state, federal, and local. We know this because of FOIA requests by the Electronic Frontier Foundation, as well as investigative work by journalists. Once again, this is part of how we alleviate these information asymmetries between public officials and the general public. And we know that drones that were allocated for use for border policing have been used to surveil protests, have been used to surveil the homes of protesters, have been used for policing of ranching disputes, right? They've been used for all sorts of purposes that are beyond the initial purpose that we devised this drone program for. So all of this raises concerns that while we don't know precisely how the powers and skills and tools that are acquired and learned through militarized counter-narcotics policy will be used in the future, they may be used in the future by political entrepreneurs in ways that we should be concerned about, and that people who are comfortable with their use against cartels might not be comfortable with those future uses. So while drug cartels have caused serious human suffering, both at home and abroad, and these transnational criminal organizations are worth responding to, we need to seriously consider the adverse consequences of both secrecy and militarization. Thank you.
Thank you. It's a pleasure to be here. I appreciate the invitation. And we've had some very good speakers here so far. I want to say straight up that I am working at the Department of Justice, but I'm not here in that capacity. I'm here in my personal capacity. So any comments I make have no bearing on the Department of Justice nor the federal government. But anyway, what I wanted to really discuss here is the administration's use of the Alien Enemies Act, because what we're talking about here primarily is cartel infiltration into the United States. How do you deal with that? There are many ways of doing it, but I think the administration's done a pretty good job so far of using the Alien Enemies Act. I just want to let you know, in case you don't know, there's a case involving this. It's WMM v. Trump. It's at the Fifth Circuit. It was sent back to the Fifth Circuit for a hearing on the 26th of January of this year. So it's still pending. Once we have an opinion from the Fifth Circuit, it will then go up to the Supreme Court, and we'll have more information on that. So this is pending law of what's happening, but I just want to discuss how the Alien Enemies Act works and its history. I think if we look at the history, how it was enacted, it will apply to a lot of things that are happening in our time today. But basically, the Enemies Act calls for the removal of natives, denizens, or subjects of a hostile nation who are within the United States. There has to be a proclamation by the chief executive, the president, who determines one of three states are occurring. It can be an invasion, it can be a predatory incursion, or a declared war. President Trump declared in his proclamation that there was a invasion or predatory incursion occurring in the United States, specifically from the nation of Venezuela through a paramilitary arm of the government, we call it TDA. So I don't know what you've heard about Tren de Agua. I'll give you the information. I've been briefed on this prior. Before I was working at the Department of Justice, I worked for the state of Texas as a prosecutor on the border. So, as you may be aware, the prior administration collapsed legally in Texas and in New Mexico. Very few prosecutions were happening, so the states had to take it up. We were, when I say the states, the state of Texas in specific was working directly with the foreign ministers and security agents of various Latin American countries. They came to Texas, they briefed us on Tren de Agua. That's where we first knew about it, because Tren de Agua was not merely coming to the United States, it was going to various Latin American countries, causing horrific problems in those nations. Some of the nations dealt with it better, some less. But we learned from the lessons they were providing us that we could do in Texas, and then what we hope now the federal government's going to be doing. Tren de Agua is not a standard cartel. Its organization is like any other cartel. It's not a Mexican cartel. It's from Venezuela. It doesn't have a hierarchical organization. It has a very, very even hierarchical nature. I'll get into that later. To get back to the declaration, the proclamation, President Trump issued that, and that was the first step in going after Tren de Agua through these means. Just to give you a legal, since it's a legal panel, I want to get the legal part out of the way. The Alien Enemies Act started, it was enacted in 1798 following a treaty between the United States and England. The French were very angry about that, and we were, as Americans, we were concerned about the French reaction to that. There was an embassy sent by the federal government to the nation of France, and we were rejected by the nation of France. There was 3 ministers in the United States that went over: John Marshall, later Chief Justice of the Supreme Court, Elbridge Gerry, who is the namesake for gerrymandering, and Pinckney, who was the direct ambassador. They went to France, to Paris. They requested to meet with the leaders of the French government, the directorate at that time, and they were rebuffed. Instead, they were met by 3 separate French agents who were not named in the diplomatic cables that were sent back. This was all coded information. They were agents X, Y, and Z. This is the famous XYZ affair. It was the first international intrigue the United States was involved in. These agents demanded bribes from the American government in order to secure themselves from the French. This caused, again, this was something which happened secretly. These cables were leaked out. It was probably the first leak of government information. It was leaked out to the public. The public were enraged that the French were demanding tribute from the United States. And the Congress came up with a series of measures to protect the United States at this time. Firstly, how much time do I have? Oh, thank you. The Navy was created. The Department of the Navy was created at this time. The Marine Corps was established at this time. The Army was strengthened by 12,000 men. There was an auxiliary Army Corps that was created of 10,000 men. All treaties with the French were abrogated, and the Enemy Aliens Act was created. The difficulty was we were concerned, America was concerned at this time, that there were foreign agents that were French that would form a 5th column inside the United States. If the French attacked us, we would be at an enormous disadvantage with foreign agents within our borders who could arrange an attack against us. There was another act that was created called the Enemy Friends Act, which was later repealed, but that was to protect, so we could deport people from friendly nations rather than alien nations. The whole point of this was, how do we protect ourselves in a time of what's called imperfect warfare? This was an imperfect war. A perfect war is a war where it's declared. We have that with World War II. We have declarations of war. We have that with World War I, declarations of war. At this time, it's an imperfect war. There is not a declaration, but there are hostilities that are occurring between states. In the AEA, Congress extended the act to authorize resident aliens to be seized and deported with virtually no legal process because this was considered to be a national security issue. The definition of the traditional concept of an alien, enemy alien was expanded. The definition of what a predatory invasion was created. At this time, predatory incursions were considered to be privateers. They were considered to be Indians. At this time, there was much concern about Indian nations attacking the United States. And those types of situations were brought to bear on the act. This case has been reviewed before in the federal courts. In particular, there's a case, Ludeke v. Watkins from 1948. The terms of the Enemy Alien Act have been affirmed by the Supreme Court as they're written. And this is the case that's currently pending in the Fifth Circuit right now, whether the affirmation that's already occurred will be affirmed by the Supreme Court today. And just transfer this over.
Thanks very much. Thanks to all of you. We have some time now for you to have a discussion up here and react to each other's comments and consider what the other panelists have said. And then after that, we'll go to questions and answers from the audience. And just open, you can just open your microphones and talk.
Sure. So my understanding, David, is that the Alien Enemies Act was partially what was used during World War II for justifying Japanese internment. Is that correct, that that was part of how it was applied in that context, or is that wrong?
That's not my understanding.
Okay.
In fact, the internments were done under a separate statute, as far as I understand.
Okay.
So that's a different matter. Because the purpose of the Alien Enemy Act is to get people from an enemy alien nation removed from the country.
Okay.
And not to keep them here.
Okay, that makes sense. All right. So yeah, I've seen some immigration historians characterize it that way, so I'll look into that in more detail to make sure that to correct my own understanding if I'm mistaken there. So thank you. That's helpful.
I guess one of the things I'll talk about the Alien Enemies Act and what my discussions about the lawful ability to use force, and then to go to your comments, what I would say is transparency, to be able to see the OLC opinions, to know what the legal authority is. There also has to be some consistency in our legal positions that we put forward so that when we're very credible in what we do. In the Alien Enemies Act, David's correct that the president issued a proclamation, and then DOJ in their filings in the Fifth Circuit said that Tren de Agua was an arm of the Venezuelan government, and we're taking direction directly from Maduro himself, therefore essentially making them part of the Venezuelan government. But yet in the FTO cases where we're using military action against the boats, we have said they are non-state actors not associated with another nation state. And that's because if they were associated with a nation state, that would be an international armed conflict with another nation, whereas a non-state actor similar to like Al-Qaeda is not affiliated. So we have taken inconsistent legal positions in federal district court as well as in presidential proclamations, because the president issued the proclamation and then he issued 2 reports to Congress. The first after the first, I think, September 2nd bombing, where we said it was in self-defense, and then the second one was after the second attack on the boats, we said we were in a non-international armed conflict. So we, even ourselves, have not been consistent in the legal theories we've had and how we're doing those sorts of things. And I think it's very important for us to do that, to have credibility both domestically and internationally.
Let me respond on that. So in terms of Tren de Agua, it is a preliminary, the briefing I've received from security officials from Latin American countries is that it is an arm of the Venezuelan military. It's specifically designed for that. TDA was a labor union group. The name Tren de Agua means train from agua. So they were building a railroad in that province of Venezuela. This group took over the union and became armed, and they became a criminal organization. They started to work throughout Venezuela. Now, my understanding of TDA is that their organizational hierarchy is nearly non-existent. They work in cells, so some of the members go to one location, they set up shop, they start to organize, they start to recruit local members, and they have very tenuous connections to the headquarters, wherever that might be. My understanding also is the main headquarters for TDA has moved to San Antonio, Texas from Venezuela. So they set up a cell, it starts to grow, and there is some kind of coordination, but it's very, very loose coordination. So it's more of a growing organization rather than a hierarchy. It's very much more horizontal than it is hierarchical. In terms of law enforcement is great for hierarchical organizations like Ken was talking about, breaking up the mafia. That's a hierarchical organization. You can do that. This is going to be a different matter because it's not hierarchical. It's very horizontal, and it's very hard to control because of that. So we're looking at different models for that. One of the most important things is to remove members of Tren de Agua from the interior of this country back to Venezuela. And that's what the purpose of the order was. If you look at prior proclamations that were made under the AEA, the Alien Enemies Act, in World War II, very shortly after Pearl Harbor, proclamation was made against German citizens who were in the United States, Italian, and Japanese. Now, that was made against the entire nation, so the entire nation of Japan, Italy, and Germany. With this one from Trump, it's against members of Tren de Agua from Venezuela. It's not against the nation of Venezuela, it's against the gang itself, so it's not against the members, not against the nation itself. So that's unique in the history of the use of the AEA. And it's related to that because it's not against the nation, it's against this armed military, paramilitary group that's made its way to our shores. And it's not so much a military organization against it, not against Venezuela, it's against Tren de Agua. It's against a cartel from Venezuela. So it's not the same as it's been used in the past. It's much more discreet than it's ever been used. And the comment about the boats, again, that has nothing to do with AEA. That's really a more of a military operation whatsoever.
So I think we're saying the same thing, but they're still using inconsistent, they're not mutually exclusive. You cannot have different legaling arguments for these two aspects, and this is why. If they really are an arm of the government and they're not organized, then we cannot then say we are in a non-international armed conflict with a non-state actor, because if they are an arm of Venezuela, then they are armed international actor on behalf of the Venezuelan government. And so we have specifically told Congress, we have said at the United Nations, that they are non-international state actors. And by saying that, we're saying they are not an arm of the Venezuelan government. So it is inconsistent. And the reason is because if we say they're state actors, then we have violated Article 2, subparagraph 4 of the UN Charter. So when we took the first boat strike, we were condemned by that it did not meet the requirements of self-defense. So after the second boat strike, this administration came in and said they are non-international state actors, very similar to the arguments we made with Al-Qaeda, and yes, they're not associated with the state, but we can defend ourselves against them, and we are in an armed conflict with a non-state actor. And because we're in a non-armed conflict, we can use military force to do so. But the definition of a non-international armed conflict under international law is there are two elements. The first is the level of organization that David has just said they do not have. To be a non-state actor for a NIAC, a non-international armed conflict, you must have a military-type organization, hierarchical organization, the ability to do military planning, and the capability to do military operations. The second is you must take some sort of action against the United States that's equivalent to an armed type of attack that has significant intensity and duration that would justify going into an armed conflict against them. The reason this was done internationally, it was initially done for internal skirmishes. So the previous panel talked about the FARC in Colombia, all within there. It was basically the international community not wanting to get involved. When we ended up facing Al-Qaeda, we had a different aspect where it wasn't limited to a single nation, it was transnational, and it was directed against us, a separate nation. So how we treat this TDA, we, the United States, still need to be consistent in our legal applications of the law, and I would really like to see the OLC opinions that justifies our ability to actually use military force against these cartels and what the equivalent of the armed attack is that we're saying that we're using self-defense and an armed conflict with a non-state actor.
Thanks for the discussion. We can open the floor for questions to the panelists from anyone who's interested.
Hi. Oh, sorry about that. Hi, gentlemen. This is actually on the topic that we were just discussing. The inconsistencies of the distinction of TDA, one being international legality and the other being a domestic process. Could you say that that separation of legal environments is why we're able to have inconsistency? Or are you just overall calling that there should be just domestic or international more consistencies in that distinction?
I would say you have to have consistency on domestic law as well as international law. We follow both. Domestically, we have a lot of laws that Congress puts in place that allows us to take certain actions. I agree 100% with Ken Cuccinelli that when designating someone a foreign terrorist organization does not have the authority within the law that says you can now take military action. There are other consequences for doing it, but it does not include doing it militarily. We have the War Powers Act, which says if the president uses his Article 2 authority to use force with the military, there's certain actions and justifications he has to do. In the past, those actions have gone forward. There's a 48-hour report that the president sent over to Congress. So to ask the question from the previous panel about Noriega, in 1989 during the Bush administration gave very specific facts. One, the democratically elected government that they had just had that Noriega did not allow to go forward asked for U.S. assistance. We were asked to come in. Number two, Noriega actually killed a U.S. service member in Panama. They brutally beat a second one. They detained a third. The wife of one of the service members was detained and was interrogated. And then we had a very credible threat that they were going to attack U.S. citizens in one of the residential areas there. So President Bush went in saying we're going to defend our citizens and our country in Panama and went in and took out Noriega. There are consequences to that too, because even though he was a drug dealer and we brought him back for prosecution, federal court found that he was a prisoner of war. And we, the U.S. government, had a separate cell for him in the prison that fell under the law of war. He had his own library. The Army went and visited him 2 times a year. The International Committee of the Red Cross, he was held as a prisoner of war. So there's different aspects. We followed the international and domestic side in how we did that.
Hi, hello. My name is Oswaldo Silva. I'm in the International Security Program here at Basin. I'm really interested in hybrid security threats, and with Venezuela and Tren de Aragua, we see that this is not a fully non-state actor nor a branch of the government, but we for sure see that Venezuela is, or maybe was, a state enabler for this dark network. So there are groups with access to instruments of national power, so they can use the infrastructure, the military, the intelligence in order to carry out their operations. So considering state enablers, should we reconsider the approach on like counter-narcotic measures? And also I wanted to know your thoughts on the Shield of the Americas initiative, considering that the US is expanding its military approach to this issue, also aiding foreign governments following this strategy. Thank you. Counter-narcotics.
Okay, I'm on. My understanding is also, as you say, this is a unique situation. We have not been faced with this before, as far as I understand. It is a state actor, but it's also separate from the state in various ways. But how allied it is, how much it's not, I'm not aware. I think what we have to look at is the situation of what's going on. In the prior administration, millions and millions and millions of people were able to come over the border unchecked. Because of that, all these various nefarious actors were able to gain access to the interior of the United States. When you look at what happened in Aurora, Colorado, there was a apartment complex that was taken over by TDA. It was a very, very, very serious situation. Turns out when the police went in and investigated, there were actually 3 other apartment complexes that were taken over by TDA. The people who owned the apartment complexes said they were not able even to get in there. Police were not able to get in there. This is similar to other situations in other countries, such as France, where we hear that there are areas the police cannot go in Paris because it's a Muslim area, and they cannot get in without serious risk to themselves. So this is exactly what TDA was doing in Aurora, Colorado. Where I was in El Paso, there was a hotel called the Gateway Hotel. It was 1 block from the US courthouse. That was taken over by TDA. They had to go in with a SWAT team. We're talking about SWAT teams. They had to go in with the SWAT team because it was so dangerous in that situation. And what they were doing, they were trafficking children out of that place, sexually trafficking children. So it's a criminal cartel. They traffic in all kinds of illegal substances, especially people, children in particular. But it's hard to know exactly what this is. We are looking at a situation, I think it's interesting, so many of you students are here. You're going to have to figure out how do we deal with this. We're trying to figure this out right now. My understanding of the national security position of the United States is that the southern border with Mexico is the last resort. We don't want to have any more threats on our southern border anymore. The new security perimeter is further south towards Panama. And there is a push right now to prevent any type of further mass immigrations coming up that would harm the United States, and any types of trafficking of illegal substances, and in particular the trafficking of people. So this is something which is ongoing, as I understand, in national security discussions in the federal government at this point. But the southern border is no longer, it's the last resort. If there's danger on the southern border, that is a failure. It has to happen. So the United States is now reaching out to other countries throughout Central America and is working to create a security perimeter for all the nations in that, from cartels that are destroying countries. We've heard about Mexico. Mexico's a fantastic place, one of the best countries in the world. But it's being destroyed by the cartels, and the cartels will destroy the United States if they can do it. So we are looking As I understand it, the federal government is looking for people of goodwill in these countries to come forward and work. There is corruption in Mexico, there's corruption in Venezuela, there is corruption in the United States. And it's in all these things. Wherever the cartels go, they corrupt the government. No one is immune to this. There is an enormous amount of corruption in the United States. And we have to end the corruption across the board, and we can do that with security measures that will keep us all secure.
Yeah, so I think we're looking at Venezuela specifically. So the justification that was sent over to Congress under the War Powers Act is that this was a Department of Justice mission, that they went in to go get someone who's a criminal, they had an indictment, and that they used the military to support them and took military actions in order to be able to get Maduro. And you'll also see some language in there that says that the Venezuelan government is unable or unwilling to, turn him over. So why is that language important? So think about Osama bin Laden in Pakistan. We went after Osama bin Laden in Pakistan. We said we were operating in national self-defense, but the government of Pakistan was unable or unwilling to actually take care of him in their own country. And that is a justification we did where we violated Pakistani sovereignty. In the situation of a rendition, which is really what going in for law enforcement purposes is, there's few occasions where we've done that. The United States did it into Mexico when they went in and got the cartel members that killed Kiki Carmina, and we brought them and we prosecuted them in the United States. We did it without telling Mexico. We went in, it was not a military operation, it was a DEA operation. What we did in Venezuela, though, is really unprecedented because we did a military operation in support of law enforcement that we had never done before. So it's kind of a new regime. So we're starting to mix some of the law of armed conflict justifications with the law enforcement justifications, where those have always been separated in the past. And we have to be careful about that because that may encourage people like China in the South China Sea with all of the various islands and fights with Vietnam and the Philippines and others to try and take control there. Or it could be Russia further in Ukraine and how they're doing things. So the rule of law to ensure that we're consistent, is my point, is very important.
The other thing that I think is worth noting with all of this is that any of our responses to transnational criminal organizations have a real risk of collateral consequences for people, collateral damage, right? So if we, for example, are trying to go after members of TDA and it's a non-hierarchical organization, and it's therefore difficult to discern who is or is not a member under some margins, what's the risk of a false positive, where we pick up, detain, deport, otherwise abuse somebody who officials say is a member of TDA, and then it turns out they're not, right? When it comes to collaborations with foreign governments for these joint law enforcement activities, there's always the risk that you will enable predatory state behavior, human rights abuses by other governments, rather than just enabling actions that restore the rule of law. At the beginning of the conference, we saw a trailer for a documentary about how one US-backed military unit in Mexico engaged in enforced disappearances. My colleague Carla Segovia is in the audience. We've written on the civil war in El Salvador, where US arms were sent to a government that was engaged in some pretty serious human rights abuses, as well as to government-aligned death squads. Plan Colombia has been mentioned as a success story throughout this conference, but there were serious human rights abuses involved in how that was carried out as well. So I think we should be really concerned about how state actions, even those that are well motivated and intended to stop genuine security threats, could generate collateral consequences for innocent people.
I would agree with Nathan on that. That's extremely important. As I said, I've seen corruption in Latin America. I've seen corruption in the United States. No one's immune from it. It will happen. There have to be institutional safeguards to protect people from corruption and corrupt officials. When I was in El Paso, I worked with the Mexican prosecutors across the border. That was fantastic. One of the most important things that we learned was we have to have interagency cooperation, and Ben was talking about that. We have to have cooperation between federal and state agencies. And most importantly, we have to have cooperation between the nations, because this is not a local matter, it's not a state matter, a nation matter, it's a regional matter. So we have to have cooperation. As I said, there will be corruption. We're filing a case probably tomorrow, not related to anything we're talking about here, against corrupt officials here in the United States. So I love corrupt officials. It makes me happy to get them. It's the love of my life. So I really do. But there has to be a way to stop these people. We talk about criminals, and I'll go with this. We have criminals. I understand why TDA people want to do their criminal activities, because they want to make money. But there's no reason for an official to be corrupt. That is not only is he defrauding other people, he's defrauding every single person that he is supposedly representing. Those are the worst people, those are the worst criminals, and they should get the most severe penalties. So I think what Nathan says is extremely important. We have to have institutional methods to stop people at the initial stages of corruption.
Hi, my name is Teresa. I'm a master's in public administration student here at George Mason. And I was continuing on with that topic. Do you think the actions the U.S. have taken, such as designating cartels as terrorist groups or the arrest of Maduro, have impacted U.S. interagency relations with Latin American allies? And do you think these relationships could be remedied?
Could you say the last half again, please?
Do you think the actions of the U.S. have taken, have taken designated cartels as terrorist groups or arrest of Maduro have impacted U.S. interagency relationships with the Latin American allies? And do you think these relationships could be remedied to work towards combating the cartels?
My understanding is that the seizure of Maduro has enormously affected relations. The Latin American countries have been overwhelmingly positive about the operation in Venezuela. My understanding is there has been much more outreach from many Latin American countries towards the United States to work in collaboration. So these types of things, again, Maduro was a very corrupt leader of a country. His party despoiled the nation. Venezuela was a wonderful country before it became communist, and destroyed the nation. And now, again, people are coming up to take over Venezuela and to stop the corruption, stop the international trafficking.
I'll talk to the gunboat aspect of it. I think the jury is still out on what impact it has. So you have to remember that even under the law enforcement aspect, for the Coast Guard specifically, we had all sorts of international agreements with Latin American and South American countries for doing drug enforcement operations, and bilateral agreement, multilateral agreements of how we would work together. And where we're now not relying and using those, it could have lasting impacts, where instead we're going to say we're just going to, kill the people that are on the boats instead, and by bombing them as a military means. So it could. I think the jury is still out.
Hi, my name is Finn. I'm also a master's student at George Mason. I'm more curious about the civil liberties aspect of this conversation about global security. In the post 9/11 landscape here in the United States, there was probably the biggest expansion of the federal government into our personal lives and private conversations and emails and social media postings. And we're kind of seeing that legal justifications are being blown open way past kind of what their initial intent was. So I'm curious how kind of our expansion of these definitions are affecting Americans, and how such broad definitions of what terrorism is and what even is a terrorist organization is affecting my rights as an American and people's rights as whatever status they hold here.
So I think, moving a little bit afield from our current conversation on the designation of cartels as FTOs, I think it's worth looking in terms of the effect on your rights as an American at NSPM 7, National Security Policy Memo 7, which designates multiple anti-fascist organizations abroad as foreign terrorist organizations, and the way in which material support charges have been used against people for political speech and protest activity. We just saw some convictions in relation to a noise demonstration in Alvarado, Texas, where one protester in attendance shot a police officer who responded to the protest, and the officer did not die. It was a non-lethal shot. But in addition to convicting that shooter of attempted murder, they also convicted several protesters in attendance of material support for terrorism. And so these material support for terrorism statutes that we've been talking about throughout the day certainly are being applied sometimes to American citizens in some ways that I think raise some genuine civil liberties concerns. And so we see this with the designation of certain political movements as terrorist organizations, and we might start to see similar concerns with the application of this FTO designation to the cartels, right? So what types of concerns should we have about who might get material support charges, right? This has already been mentioned, right? In areas where cartels control a large amount of territory or where they're engaging with people, what types of interaction with a cartel member might count as material support for terrorism, right? Under the Supreme Court's ruling in Humanitarian Law Project v. Holder, certain activities carried out by civil society organizations that included offering, for instance, legal advice or other types of advice to designated foreign terrorist organizations, that was deemed material support. And their attempt to challenge that on First Amendment grounds, that attempt to challenge the law was rejected by the Supreme Court. The material support charges were upheld by the Supreme Court. And so I think that whenever we're designating groups as foreign terrorist organizations, the extent to which material support charges might chill speech and association and undermine civil liberties seems like a valid concern. To the extent that we're allowing extrajudicial killing, we should be concerned about this. To the extent we're lowering the due process requirements for deportation, we should be concerned.
Yeah, I agree with my colleague Nathan here a lot. I think that what's happening here is, the Alien Enemies Act allows a rescission of due process rights. It very clearly does, because it's a national security issue, and it's in a period of emergency. And again, like Nathan says, we have to be careful about when emergencies are declared by a federal government because they can be abused. In preparation for coming here, I decided to read, of all things, the opening statement by Justice Robert Jackson at the Nuremberg trials. It's about 70 pages long. I think everyone here should read it, especially the students, because there's probably no greater deprivation of human rights than the Nazis did. So it's how did that ever happen? And if you read it, he provides a very good description of step by step by step. How did it happen? Everyone needs to know what not to do. And in that, you probably know that Hitler came to power because of an emergency declaration of the government. There was an emergency. But according to German law at that time, the emergency could last no more than 2 months. Well, they just let it go. No one bothered to stop it. So 2 months became 3 months, became years, and you know what else happened. So there are provisions in the law almost everywhere to prevent these things from happening. But what we have to have is people in various positions who are willing to stand up and say when the law is being violated. That's why lawyers exist. That's why lawyers are being trained. We are trained to stand up for people's rights. And some of the rights that exist are human rights and civil rights. And I wasn't there at the time. I'm just reading what happened. Why did people not stand up at this time? I don't know. But There has to be enough people who will stand up and say, these are not the rights that we have. These are the rights we have in law. As far as I understand right now, is everything I see, AEA is not a deprivation of rights against the law. The Supreme Court in its preliminary decision said there is some process due to people who are detained under the AEA, but that's unclear as to what it's going to be. The prior case law on that, mainly Ludeke v. Watkins, says there is no right except for a habeas hearing, which is some due process, but it's the minimum amount. But the Supreme Court says there's some, but how much? Don't really know. We're going to have to wait for that. But these are the types of things that have to happen. Right now, with Tren de Agua coming over into the United States, what I saw personally in Texas and other places, it was an emergency. There was nonstop movement coming across. There were breaches across the border by thousands of people who rushed at one time at multiple locations in coordinated efforts. So there was huge numbers of people just pushing across the border, thousands at a time. There's not enough law enforcement officers who can stop it. So that was an emergency situation. It's not happening anymore. But I think Nathan has a very good point. We are responsible to make sure that the law is carried out appropriately.
Good afternoon. Hopefully my question makes sense. So Bob Osgood, Electrical and Computer Engineering Department. So I've worked Colombian drug trafficking organizations. I've worked Dominicans. I've arrested them. I've worked with U.S. attorneys' offices in prosecuting them. So now drug trafficking organizations are now being identified as FTOs, okay? And my question has to deal with, I've had to deal with this issue, right? So we're talking now more, potentially the intelligence community getting more involved. They've always been involved, but more involved, right? The intelligence community, however, works upon an idea of facts and opinion to develop a probability. Right? So recently the DNI testified before Congress, and every time she said something, she talked about the probability of it happening. Well, I'm a criminal investigator. I don't deal in probabilities. I deal in hard facts, right? I got to get this thing to be demonstrably correct, right? So my question is, and I've had to deal with this in my own professional career, how do we reconcile the two now that we're driving down this FTO road, and historically, we've been working these things as criminal cases. Now we have potentially a different world here. Thank you.
So a couple of things. Thank you for the question. So as far as the intelligence aspects and the intelligence communities, they've never been prohibited from collecting on cartels or anything that they're doing. It's all about resources and where you're going to put your focus. I mean, the previous 20 years, it's all going to be on counterterrorism where they are. If under this administration, they're saying that they want the focus to be on the cartels, then the intelligence community, based on the direction of the president, needs to change their focus and put their resources to be able to collect in that type of environment. As far as the different regimes, whether it's a military regime or a law enforcement regime, so there's domestic authorities that we've relied on for years for the law enforcement aspect, but we haven't always used those resources and focused those resources to the extent that we are now. And let me explain what I mean by that, and to expound a little bit about what the previous panel talked about. So domestic law says that for drug detection and monitoring, that responsibility is with DOD. The interdiction is with the Coast Guard. They're both military organizations. You have two specific task forces within DOD. Joint Interagency Task Force South, which is down in the Miami area, and Joint Interagency Task Force West, which you don't hear about as much, which is in Hawaii. And that one is focused on the Golden Triangle in the Thailand, Vietnam type of area. You probably don't even know that the military has put in intelligence fusion centers going back before 9/11 in that Golden Triangle area to do counter-drug operations, to share information internationally as well as with our own law enforcement. So the way it works with our own military forces, where the Coast Guard has law enforcement authority, and they do this in the Pacific, which would be Joint JADF West, as well as in the southern approaches in the Caribbean, which is JADF South. Both of those commands are DoD funded and located organizations, but the commander is a Coast Guard admiral. And so what they're doing is DoD is collecting all the data, they turn it over to the Coast Guard, then the Coast Guard interdicts. But the Coast Guard doesn't have a lot of resources. If we had taken, all of the Navy ships and put them down in the Caribbean, similar to what we have done recently with increasing the forces, and you heard Secretary of State Rubio say every one of the ships that we've actually bombed and hit with a drone strike, we could have interdicted them. But we've chosen not to because we're sending a different message. And I understand the different message is a different deterrent, but we're also missing out on some of those things. The military side, General McChrystal in his book, if you've read his book, the acronym F3EA, Find, Fix, Finish, Exploit, Analyze. The whole purpose of that was you can't disable the terrorist networks by simply bombing them out of existence. His special forces went in, they captured those people, they exploited their phones, and they interrogated them and got the information. They analyzed it, then they went to the next mission. That is the same law enforcement type thing that if we put enough resources into the Caribbean or other places, you could do the same sort of thing under a law enforcement model that we've done for years. Is they'll take a single Coast Guard officer, put him aboard a naval ship, turn tactical control of that ship over to the Coast Guard. That whole Navy ship is a law enforcement ship. And they take down drug cartels on the high seas. It's just now our policy is, instead of doing that type of law enforcement and then exploit it and then go after the rest of the cartel with the info, we're sending a different message as if you try and come, we're going to hit a drone strike and we're going to kill you. So it is different regimes. We do have a lot of authorities to do it. The question is the will and the resources to be able to focus on it.
I think you made a vital sort of epistemic point about the different standards of knowledge that are being acquired, right? If you're a criminal investigator who's trying to then be able to assist in prosecuting somebody and you want them to be able to be convicted in a criminal trial by a jury, you want something that meets the standards of beyond reasonable doubt. Whereas if you're engaged in intelligence activity, you're operating with a different set of objectives related to identifying probable threats. And so I think that epistemic distinction is important, and that might raise a set of concerns about where are we going to see different types of errors and which types of errors that result from different institutional contexts are we more or less willing to tolerate.
Any other comments?
Just one more comment. I think, as you say, it's going to be a hybrid. There's going to be some prosecutions, there's going to be some military actions, and it really depends on what happens where. Of course, people who are apprehended here in the United States are going to go through criminal prosecutions. But also you have people who have U.S. indictments. Maduro had an indictment, so that will be a criminal prosecution. The U.S. issued, I think, 30 indictments. DOJ, was it last week, for these types of situations overseas. So that's the criminal side. But then there's also the military side, which is about national security. DOJ is not the center of this. It's going to be DOW that's the center.
All right, we're at time. I want to thank the panelists for an interesting discussion and the audience for interesting and engaging questions. Thanks very much.
And now let's take a 5-minute break, and we'll reconvene at 4:05 for the final panel of the day.